Good evening, friend. Welcome you all at the Rising Bharat. We have a very special episode called Legal Eye. Here we learn about the various aspects of the legal news, and at the same time we learn about the cases and what are the various complications of the cases where we deal with it on the day-to-day basis. और आज जो केस लेकर हम लोग आने वाले हैं बहुत फेमस केस है, ये है प्रियदर्शनी मट्टू का केस है. She has been raped and killed by a law student of Delhi University. और इस केस में मोस्ट इम्पॉर्टेंट बात है जो 3 फैक्टर्स हैं. नंबर 1, ट्रायल कोर्ट में बिकॉज जो कन्विक्ट संतोष सिंह, was the in fact was the son of retired IPS officer and he was the convict. And ट्रायल कोर्ट में क्या हुआ कि ट्रायल कोर्ट में ने उसको विदाउट लैक ऑफ एविडेंस के कारण उसका एक्विटल हो गया. एंड उसके बाद एक मास मूवमेंट बना. देयर आर लॉट ऑफ पीपल हैव गैदर्ड एंड दे हैव डन लॉट ऑफ एजिटेशन. मैटर केम टू द हाई कोर्ट और हाई कोर्ट ने जो है वो फिर से जब एग्जामिन किया और उसके बाद जो हाई कोर्ट ने जो एविडेंस दिया उस एविडेंस मतलब हाई कोर्ट ने जो फाइनल जजमेंट दी उसके अकॉर्डिंगली संतोष सिंह को जो है ही हैज़ बिन गिवन डेथ पेनल्टी. और लेकिन मैटर फिर जो है वो बिकॉज ये केस 1996 का था, 2010 में जाके उसकी डेथ पेनल्टी दी गई और उसके बाद फिर आगे मैटर जो है फिर सुप्रीम कोर्ट में गया. तो सुप्रीम कोर्ट ने जो है वो उसके कन्विक्शन को बरकरार रखा, लेकिन जो डेथ पेनल्टी था उसको लाइफ इम्प्रिजनमेंट में कन्वर्ट कर दिया. तो ये बहुत ही जो है वो बहुत ही रिमार्केबल केस है. और इसकी अभी चर्चा इसलिए हो रही है क्योंकि अभी इस केस में जो है जो संतोष सिंह की तरफ से प्री मैच्योर रिलीज़ के लिए जो है वो स्टेट रिव्यू बोर्ड को भेजा गया था एप्लीकेशन और स्टेट रिव्यू बोर्ड ने इसको रिजेक्ट कर दिया. तो ये मैटर फिर दोबारा जो है वो हाई कोर्ट में आया और हाई कोर्ट ने जो है कहा है कि आप इस डिसीजन को दोबारा रिव्यू कीजिए बिकॉज देयर इज़ ऑलवेज एलिमेंट ऑफ रिफॉर्मेशन. Now we will be addressing any questions from you guys on the same matter.
So, sir, my question is whether the circumstantial evidence adduced was sufficient to establish the guilt of the accused beyond reasonable doubt in the Priyadarshini Mattoo case.
You just see it is
Whether the circumstantial evidence adduced was sufficient to establish the guilt of the accused beyond reasonable doubt in the Priyadarshini Mattoo case.
You just see there are a lot of judgment on this. Of course, prima facie circumstantial evidence is taken into the consideration. For example, I can tell you, let's say in a room if there are 2 persons and one person dies, so in that case the burden of crime immediately will come on the second person. And most of the cases you will see, if the 2 persons in a room, one person dies, then the first arrest is being done to the second person who is in the room. So this is what the circumstantial evidence. But if let's say in the defense evidence the so-called accused is able to prove that, he has to counter that circumstantial evidence. And that's for the reason if we go into the high court, most of the appeal goes on the real evidence, material evidences, not on the circumstantial evidence. And that is the reason what happened in the appeal. Normally these cases fails. So this is a very, very important thing which we need to understand that because the circumstantial evidence will not be taking you to the final level of appeal, because in the appeal if you don't have a material evidence, then the result of the case will be otherwise.
So the question that says whether the delay in the disposal of the appeal violates the victim family's right to access to justice under Article 21 Act.
You just see, yes, we can say that, but you just see the court has its own procedure. When the court look into the matter, they look into the matter in the very holistic way. Basically, because if we get into the fundamental basis of our constitution, that says that an innocent should not be punished whatever the circumstances. The most important thing is that where accused get several opportunity in the form of appeal, and So in the process of those appeal, whether it's a start from trial court, high court, Supreme Court, it does take time, and it will take time because we are a very populous country. But the essence of justice will remain, because in this case you can see that the trial court has uh, basically released the accused, or he has been acquitted from the trial court. For example, this is the incidence of 2006. Within 3 years the trial has been completed, and 1996. This is a case of 1996, and 1999 he has been acquitted. But 2006, when the matter went to the High Court, finally the decision has been reversed, and he has been found guilty, and he has been given a sentence to death. Again, the matter, when it gone to the Supreme Court for final appeal and all, the Supreme Court upheld the judgment of the High Court. Just they have changed the death penalty to the life imprisonment. So this is the reason what I say, like that is the beauty of our constitution, that it gave fullest opportunity and to the accused or the other party, where they can take all the possible remedies in for the sake of justice.
Sir, मेरा क्वेश्चन है कि whether the Supreme Court was correct in committing the death sentence to the life imprisonment under the Reyes doctrine.
Yes, like this is the decision of Honorable Supreme Court in several cases in the practice. As yes, the question is like I want to say, yes, you just see the death penalty has a lot of controversy into this matter, and I want to tell you, like if you go with the international jurisprudence, where so many countries where this death penalty does not exist, okay, because they have a strong belief we cannot give life, therefore we cannot give death. Okay, the terms of imprisonment can be 10 years, 20 years, 30 years, whatever, but they don't go for a death penalty. There are only few countries there still the death penalty exists. So therefore, like as I say, considering that he was a law student, maybe that age must be around 22, 24 or 25, that must be. And looking into the whole situations, what happened, the law somewhere try to give an opportunity or giving another chance to live. That's very, very important. And therefore, considering into these things, when they may not consider is as this is a very rarest to rare case where the death penalty is required. So therefore, the Honorable Supreme Court take a decision like converting the cases into the life imprisonment, because that give a person maybe an opportunity to live and same time reform, repent. These are the things.
So sir, what do you think the lowest role in this case? How come it affect the society?
You just see, this is a very, very exemplary case, like how the lawyer plays a very crucial role in any case. For example, in this case, if you see in the trial court, the accused got acquitted. Okay, it means he has presented case in such a manner. Maybe the defense lawyer could not make it, and the defense lawyer was far strong than the prosecution lawyer, and the prosecution, they could not present the case in the right manner, and as a result he has acquitted. But on the other hand, when we come to the High Court, again there is another lawyer where on the side of prosecution has been so strong that, and he has got the strongest punishment for the accused. So you can understand, like where it's not only it has gone till the highest punishment which is in this country for the heinous crime. And when the matter goes to the Supreme Court, so finally again there is a role of the lawyer, because who was playing the defense, at least he could able to convince the judge that this is not the rarest case where the person need to be given the death penalty. So that has, at least that lawyer has got the life to the accused. Because as a lawyer in our profession, we have to work without prejudice. This is a very, very important aspect of profession. What you know about your client, what you don't know about the client, that's not an issue. Issue is that you are presenting the case in the front of the judge in your best capacity, where you can get the justice for your client without any prejudice. Sometimes it looks like okay, it's all about giving the best. Either you are working for prosecution or you are working for defense, but end of the day you are working for the justice of whomsoever party you are. So that way what happened, I feel in this case, the lawyer's role at the different stage has been exemplary. So I hope this is a discussion where we can have a lot of learning from this, and we can keep on taking other as a lawyer.